I would like to ask if any other Americans out there are in a situation similar to mine, and if so, have you found a productive resource to go to? Under certain circumstances, there is a conflict of interest between Federal Law Affordable Care Act, ACA, and Federal Law Family and Medical Leave Act, FMLA. Now, briefly, my situation is this. In 2014, I was and had for some years been working for a certain employer. And that employer used a certain insurance carrier whose network of providers and whose health plan insurance coverage were extremely well matched to the healthcare treatment regimen that I had been following, not only because it was good for my welfare, but because it is this very regimen, these very stipulations, this frequency of appointments and what have you, that my medical provider has identified on my FMLA paperwork. It is these very stipulations which I must adhere to in order to maintain my job protection under FMLA. And it is FMLA that protects my employment against absences that are caused by the relevant covered health condition. Now, somewhat later in 2014, or whenever exactly it was in 2014 that my employer was purchased by another company, I learned at some point toward the end of 2014 that the purchasing company uses a different insurance carrier, and that carrier's network does not include the provider to whom I had been frequently going. It does not include that provider to whom my medical professional specifically sent me for the purpose of my well-being. Now, once I found that out about the new network, I checked into quite a number of options. I checked to see if there was an affordable individual plan that would include this provider. I checked to see if there was an affordable way to maintain the coverage that I had with the original insurance carrier. I also checked online and over the phone to see if I could qualify for subsidizing. And the answer that came back on every one of these inquiries was negative. So it left me with a tremendous decision to have to make. Because at the end of 2014, through no doing of my own, that insurance that was well matched to my FMLA situation was going to come to an end. And I had to, out of due diligence, I had to take an honest look at my finances and determine as best as possible, would I be able to financially afford to enroll in this non-serviceable insurance through the new carrier? Could I afford to enroll in that insurance that does not help me with my FMLA situation? Could I afford to throw money away on that month after month in 2015 and yet still have sufficient funds for the office visit co-pays and related expenses for these mandatory appointments? Plus the fact that when there's an upheaval in this relevant health condition, I sometimes end up needing additional appointments, and that means more expense there. Could I financially afford to do both? And the answer was no. It would have been reckless at best. At the very least, I would have been jeopardizing my financial capacity to continue to comply with those stipulations on my FMLA paperwork. And those stipulations were not pulled out of thin air. They were specified and identified by my medical provider because they constitute the regimen that has been so beneficial for my continued improvement in terms of this health condition. Now, every time I have scanned the Affordable Care Act, I have not found an FMLA-based exemption to it, nor have I found even a mentioning of FMLA. Now, why is that? In this kind of scenario, there's absolutely got to be an FMLA-based exemption to the Affordable Care Act. Now, in order to raise awareness on this issue, I contacted more than 80 senators in the United States Congress, whether by voicemail or email. I sent a hard copy letter to President Obama in February 2015. I contacted the Department of Labor. I forwarded a small amount of this information to the Department of Justice, also to the United States Supreme Court. I contacted a number of entities in the press. I also explained this conflict of interest on the comments line of Health and Human Services Secretary Burwell. I've also contacted advocacy groups. And on February 10th of 2015, I met in person with a staff member in a Colorado branch office of Senator Michael Bennet. I've also forwarded this information to Senator Cory Gardner, and I have forwarded casework documentation to a Colorado branch office of Representative Doug Lamborn. Now, my first effort to reach the Department of Labor occurred in mid-March 2015. I emailed a summary of this conflict of interest to the attention of Secretary Perez. I ended up getting a call back from somebody else, and between mid-March 2015 and May 18th, 2015, there was correspondence of a sort, very limited correspondence between the Department of Labor and me. But there was no resolution, there was no productivity. So again, I raised the issue with the Department of Labor. And on May 18th, 2015, I received a phone call from the number 202-693-9999. And it was somebody from the Washington, D.C. office of the Department of Labor Wage and Hour Division. And that is the very division that administers FMLA. So I explained again this conflict of interest situation. And then at one point in the phone conversation, just as fast as lightning strikes anything, this person began to engage in bizarrely accusatory, demeaning behavior toward me. That person stated outright that I was to blame for this situation because I didn't just up and leave my current job and go to another job. Well, not only is that outright ludicrous on multiple counts, but my investigation has shown that my FMLA job protection would not follow me to another job. If there's a way that it could, my investigation has not revealed this. The staff member also went on to say that I should have just switched providers. Well, maybe that's not even an option for me, and maybe that wouldn't be good for my health, and in fact, maybe it would be outright dangerous to it, and it would be. And maybe my medical profession would never sanction such a reckless, rash change. The staff member also went on to say that I should just call up my doctor and have her change the stipulations on my FMLA paperwork. And then that staff member contemptuously asked me if I expect the Department of Labor to accommodate every individual situation. Well, it seems to me the Department of Labor would want to do its very best to try. After all, if you're in an office of public service, you're supposed to serve the public. You're not supposed to accuse the public or be demeaning or derogatory to them. And because this staff member's behavior, and because there was no valid excuse for it, I twice phoned this information through to the Department of Labor Office of Public Affairs. I also said I want them to email me a waiver form so that a certain member of the press could contact them directly about this conflict of interest. I gave that office my phone number and my email address. I never received a return phone call or an email, and I certainly never received the waiver form. I also decided to approach this on a state level. On February 20th of 2015, I went to the website of Colorado Governor John Hickenlooper, and I came across two interesting links. On that day, I left a voicemail explaining this conflict of interest to the Constituent Services entity. On the same day, I emailed this conflict information to the Citizens Advocate Office. Now, by March 6th of 2015, I had not heard back from either of those, so on March 6th, I went back to Colorado Governor Hickenlooper's website, and I directly emailed him about this conflict of interest. Now, as for having written the president, I did ultimately receive a response letter from the White House. And the first paragraph reads as, "Thank you for writing. Because of the Affordable Care Act, over 11 million Americans finally have access to quality, affordable health insurance. However, I know there are still a lot of questions about the law and how it affects people, and I appreciate your reaching out on this important issue." Well, whoever wrote this letter, I need more than your appreciation. I need more than that. And had you extended only appreciation to all of these people who allegedly now have access to this insurance, then they would be no better off in their scenario than I am in my scenario. And what is that scenario? I stand to be penalized in 2016 at the hands of a federal law for having done my best in 2015 to maintain my capacity to continue to comply with a federal law. It's like being punished by dad for having obeyed mom. The last paragraph of the letter says, "The bottom line is that we are implementing the Affordable Care Act, not repealing it. I'll work with anybody to improve this law, and I'll listen to good ideas. But for the father watching his daughter receive much-needed cancer treatment, or the senior citizen saving on prescription drug costs, we can't go back to the way things used to be. This law is helping people, and it's here to stay." Well, I won't guess as to who wrote this letter because there is no typed name below the signature, but this is what it shows. But anyhow, whoever wrote this letter is stating categorically that he or she is opposed to the harming of people, especially via this law. Well, that automatically means that you can't sit back and permit the harming of people at the hands of this law. If you support this law because it's allegedly helping people, you have to be opposed to the harming of people at the hands of this law. And this law is harmful to me in a number of ways. And one of those ways is this conflict of interest that I've explained. There has got to be, morally, logically, rationally, there obviously has got to be established an FMLA-based exemption to the Affordable Care Act. It's necessary, it's mandatory, it is moral, it is needed. Thank you for listening to this message.